Good morning.
Good morning. I can't
How
see
are
you just
you?
yet. I'm well. I'm well. How are you?
I'm doing well, thank you.
Haven't spoken to you in years.
I was thinking that when I got your message, I'm like, does she still have my phone number? I was a little bit surprised.
you know,
But anyway,
I just didn't understand how come you weren't in the mix because you're so good. I remember you during the Dunn trial. I said, wait a minute.
we were doing it all the time. But no, this is actually a case that I could feed you a bunch of stuff
That
on
would be
this,
great.
depending on how it goes, whether it's today or over the course of the trial. So whatever I can do for you, I'd be happy to do.
I'm glad you said that because I was going to ask you if you'd be available in the morning hours because once the trial does start, we're planning on live streaming not just on online but also on air on 26.5, even though the station that we have. So we're planning on streaming the entire trial and throughout the trial. Obviously, during breaks, we want to pull people in to do analysis. I was hoping that you would be available in the morning hours. I guess on certain days, I'm going to ask you ahead of time to see when you
Yeah,
are.
no, I have two Siberian Huskies, and so they wake us up in the morning and make sure that they go for the walks and they go get fed. So yeah, morning hours are fine.
Okay,
I
good.
got a little bit of a sinus thing going on right now, but I'm fine.
Okay.
But anyway, but no, morning hours and review because jury selection is so huge in this case, and I have so many opinions about this case that
Yeah.
I could, I can give you sound bites anytime you want.
Great. Well, this is going to be a full 30-minute chat. So normally I ask you to talk in bites. I know you can, but that's not what we're doing. We're just talking. We're just chatting
I
things out.
have,
Now you look kind of dark. Is there any way you could turn on a light in there?
yeah, yeah.
Another light? Oh, there we go.
Is that better?
Yes, much better.
Okay.
All right, looks good.
There we
So,
go. Since it's just you and me, I
yeah.
just had my contacts taken out, so I'm wearing my glasses today.
Okay.
So don't judge me. I'm not used to wearing glasses.
Please, I live in glasses for the prompter. Right now, I'm fine. So what normally happens is I don't get a warning. So at 8 o'clock exactly, we're on. We're gonna be live. So I'll introduce what's going on, the very latest in the jury selection process, and then we'll get into things. And thank you for those notes, by the way, those detailed notes.
Well, I started to do it last night, but I got up early. I tend to work early, so the morning hour thing is fine with me. So don't worry about that.
Perfect. Okay. And then I do want to get into the fact that you mentioned the Maddie Clifton case. I didn't realize it's one of the few that we actually had move venues because I didn't realize what goes into that. By the way,
It was the only
one.
case.
Wow.
I've been practicing here 30 years. It's the only case that's ever been moved.
All right, Richard. It's now 8 o'clock. We're going to go ahead and welcome folks in. You are watching right now First Coast News' online coverage of the trial of three men charged with murder in the shooting death of Ahmaud Arbery. Ahmaud Arbery, at just 25 years old, was shot and killed in the Satilla Shores neighborhood there in Brunswick within Glynn County back in February of 2020. Arrests weren't made until May of that year, and now fast forward to October of 2021. The Arbery family that I've spoke with, they say that finally they are hopeful to get justice. Now, right now, we are in the jury selection process of all of this. The trial really just started last week, Monday. So it's now week 2, day 9 of this jury selection process. The pace moving rather slowly, but we'll get into that in just a bit with why that needs to happen. So let's just get you caught up in the very latest right now. At this point, the pool stands at 47. 47 potential jurors have been chosen thus far. The judge is aiming to get to a number of 64. Now, all that 64, that large pool of people, they're going to go through another round of questioning, and then ultimately the goal is to whittle that down to 12 impartial jurors and 4 alternates. Will that happen? We're waiting to see, because we do know that today, Friday, was supposed to be the day that they had all of the potential jurors seated. That will not be the case, obviously. It'll likely happen next week. But we're going to pull in Richard Kurtz, who you see right there, Attorney Richard Kurtz. We appreciate you waking up with us this morning to give us some insight in all of this. Richard, you've been with us through many trials before here as a First Coast News analyst, so you have some great insight. And we were just talking off camera just now about this case and the pace of it and why we're seeing the jury selection process go so slowly. That's something that you are on board with. You say it's something that's necessary in this case.
Absolutely. I think they're taking their time to do it right is crucial. The most important part of any criminal trial, especially when you're dealing with a homicide, is the jury selection process.
Recording in progress.
What you have to do is you've got to talk to every juror. You can't just simply go, I can't remember what, Tim Deegan said. I can't remember what somebody else said. You have to be able to talk to every single person and take your time. So while it may be frustrating to a judge or it may be frustrating to the family, it's critical if you don't want the case to get reversed on appeal. If you want the case to be final and you want to do it correctly, you just have to do this. It just takes time to pick the right jurors. And we're talking about such a small community. It's just going to take some time because, people are going to have their biases. People already know the story. So it's going to take some time. So I am not disappointed that it's taken this long.
And not surprised by that either. So you mentioned the community, small town, 85,000 or so people there within Glynn. Of that number, we know 1,000 potential jurors were initially pulled in. They were given summons. You hear that number, 1,000, and you're thinking, oh my gosh, that's a large number of people. But again, it was necessary in this because what we're seeing in the questioning, I'm sure you're watching this as well and seeing this, a lot of the people being questioned are saying that they know the key players within this case. We're talking about the defendants as well as the Arbery's, the victim's family. So it's kind of not surprising that they needed such a large jury pool. But again, the pace of things is leaving a mark on some folks. Even the Arbery family, we spoke with the aunts outside. They are getting a bit frustrated saying, what is taking so long?
Well, and they should be patient because nobody ever wants to do this again. Okay. Mm-hmm. If this is going to go correctly and you're going to get finality in this thing, it has to take its time and you have to do it correctly. And you mentioned the victim's family, you mentioned the defendants and their connections. But also, what people don't think about is that law enforcement officers that are involved in this, mm-hmm. they have family members, they have friends, and they have opinions about things too. So it's the entire community. It's not just the Arbery family or the defendant's family. There's a lot of moving parts in this kind of thing. So. They should take their time, and I'm glad they're taking their time. And actually, I think it should go another week, if you ask me,
wow.
Or at least to Tuesday or Wednesday to do it properly so that you don't have to put the victim's family through this again one day.
Now, Richard, you practice law here in Jacksonville. You're not affiliated with this case in any way. You're just giving us analysis as an FCN, a legal expert here. But I do know that you've been down this road before, right? It is difficult to find an impartial jury under normal circumstances. So under a case like this where it's gaining all this national attention, it's a small town, will it actually be possible to find an impartial jury?
My opinion is no. I think this case should have been moved. When I say that, I mean that very firmly, that this case should have been moved, whether it's even up to Savannah, whether it's to Atlanta. This is a case that should have been moved out of that jurisdiction. Judges are hesitant to change venue because of the cost and things of that nature. And you have to put the victim's family through the travel cost. You have to put the court through the travel cost. But at the end of the day, if you're going to give these three gentlemen or men a fair trial, I'm not so confident that you're going to get the jury that could truly be fair and impartial.
You mentioned something a lot of folks were asking earlier on that kind of got squashed over this week. I haven't heard it as much, but I remember I was down there in Brunswick last week on Monday, Tuesday during the beginning of this, and a lot of people were asking, what are the odds of there actually being a change of venue in this case? At this point, do you see that happening?
No, it's too late. No, unless, I say it's too late. I do believe it's too late. I firmly believe that. However, if there's a mistrial or if they're unable to seat, a juror or jury, then yes, then it could be moved. But it's kind of too late at this point.
And even the process itself, you were explaining to me what it actually takes. This is a lot of money, a lot of time, right. And hours that go into this. What do you do? What is the process like to actually change venue?
Well, if you change venue in Jacksonville, the Fourth Judicial Circuit, they almost never change anything, and I mentioned that to you. South of us, they change venue very often. It's not unusual to change venue to get a fair trial and a fair jury. But then you have to move the judge, all of the lawyers, prosecutors. We have 3 defendants. We have probably 6 defense lawyers. We have to move the clerk's office. We have to worry about the court reporter. We're going to have to worry about security. We're going to put all of these people in hotel rooms. We're going to have to move them, basically move the entire courthouse to Atlanta or somewhere else. And the cost of that is obviously going to be astronomical. But if we're going to do a fair trial, then sometimes you just have to do it. And but judges are extremely reluctant to do it. And obviously, in this community, it should have been done, in my opinion. It should have been done. But judges just don't want to do it because of the cost.
Yeah. Richard, let's say that you were one of the defense attorneys in this case. How concerned would you be at this point with the process and how things are going in terms of, 1, seating an impartial jury, and 2, them actually having a fair trial, the defendants in this case?
The concern, as you know, I've done several, high-profile cases, and I've tried several, homicide cases, death penalty cases. The concern you always have is what we call a stealth juror, somebody who actually wants to be on a jury panel. I mean, most people, when they get a jury summons, they go, how do I get out of jury duty? Who can I call? Who can, whatever, how can I get out of it? But in cases like this, in cases, that are high profile, sometimes jurors want to be on the jury and you don't know it. And so you have to have concerns about whether they're being truthful with you when they're answering their questions, or if they're just simply trying to get on. There's obviously a group that wants to get off, but there is a group that wants to get on. So that's something, as a defense lawyer, when you're doing the questions, you have to talk to each individual juror and get a feel for each individual juror, because nobody wants to say they can't be fair and impartial. Everybody wants to say, I can be fair and impartial. Yes, I can follow the law. Yes, I will follow the judge's instructions. But sometimes they're not always being honest with you. And so you have to take your time to get to know each juror. So that's why I say that taking this amount of time for the jury is a good thing. It's a good thing that you got to know the jury. The judge needs to know the jury. The prosecutor needs to know the jury. It's about, you have your day in court, and this day turns into a week, 2 weeks, 3 weeks. But if you want finality and you want a true verdict, you have to take your time.
So grateful to have you on here this morning, because your insight is so important in my opinion, because there are some things that we're seeing happening inside the court and you're thinking to yourself, why is this okay? Just yesterday, we heard an 18-year-old girl say she did not want to be on the jury. She felt as if she was too young to be able to determine someone else's future, someone else's life. We're talking about 3 defendants here. She was chosen to go to the next round.
And that's, when you do enough of these cases, you find those kind of things happen, and you wonder to yourself, why is the judge allowing that, or why is the prosecutor allowing that? And what happens is, when you get to the actual, once they whittle it down, there's what we call peremptory challenges, and then there are cause challenges. So what is being said is that she thinks she could be, apparently somebody thinks she could be fair and impartial and be on the panel, but somebody can clearly strike her later if they don't feel, whether it's the prosecutor or the defense, somebody can strike her from the panel. Just the fact that she made it to the next level doesn't mean she's going to be on the 12-person or 4-person alternate panel.
When I heard her speak, I thought about Michael Dunn's trial. I don't know if you remember that, the first trial back in February of 2014, I believe it was. There was a young lady on the jury who was just 21 years old. And when she was interviewed afterwards, she sounded confused, kind of like she felt as if she was too young to be on there herself. I'm sure a lot of people on the outside looking in felt the same way. So you kind of question, at that age, are you even capable of judging in a case like this? You are pretty much judging someone else's life and determining their future.
Well, and you said a couple words that come up all the time when we're in jury selection in the trials. Is you're really not judging the person.
Mm-hmm.
What you have to do is make your decision based on the evidence.
Mm-hmm.
You're not judging a human being. Mm-hmm. You're not trying to decide if he's a good person, bad person. You're supposed to say, state has a burden of proof.
Supposed to, but human nature.
Oh, no. Listen, I could talk to you all day about jury selection and whether I think people are telling the truth or not telling the truth, or whether they're stealth jurors that want to be on the panel, or there are people that just want to be off the panel. But I understand human nature better than anybody else. Having picked, I say better than anybody else, having tried so many cases, no, it is human nature, and people do feel that way. And that's why, like in the death penalty cases that I try, people get hung up on the idea that they may be imposing a death sentence on somebody. Now, fortunately, in this case, it's not a death case, but those kind of issues do come up, and people feel like they're, and that what you just said was, it's typical where people say, I just can't judge another human being, and I can't do that. Well, you're not judging the human being. What you're supposed to be doing is listening to the evidence, evaluating the evidence, and following the rules, and then you make your decision whether it's guilty or not guilty, whether the state proved the case beyond a reasonable doubt. And that's what you're supposed to do. And then you deliberate, you follow the judge's instructions. You're not judging the person. You're just basically judging the state's case. Did the state prove it? Did the law enforcement officers provide the correct evidence? Did the witnesses provide the correct evidence? And you base the credibility of the witnesses, and then you make your decision after that.
Let's talk about outside possible distractions. We did hear the day before yesterday, the defense arguing that the demonstrators outside were somehow swaying potential jurors. In a case like this, though, you expect to have demonstrators, which we're seeing pretty much every day throughout the duration of this trial so far. As every day there's demonstrators outside protesting. You see the sign saying "Justice for Ahmaud." There's even a little child that was brought up. He's about 3 years old. He rides on a little motorcycle with the "Justice for Ahmaud" on his back. And the defense was saying that's a distraction. It's a problem. Even had a problem with a button that Ahmaud Arbery's father, wore inside the courtroom. Your thoughts on that? Because the judge did ultimately say, no, that's not going to affect things. What are your thoughts on that?
This is why we come back to the topic we talked about earlier, that the case should not be tried there. It should not be tried there. I mean, the judge, and I don't want to be critical of a judge or the judge's ruling, but my opinion, based on everything that I know about this, it should not be tried there. Is it possibly a distraction? Yes. Then we come back to the jurors that we've been talking about. Are we going to be able to find a fair and impartial panel? I've tried to move venue in Jacksonville on homicides and death cases maybe 20 times, okay? Never been granted on my behalf. But we have, well over 1 million people. We have 1.5 or 1.8, whatever our population has now gotten up to. Mm-hmm. That's different because we have people coming in that just got off a naval ship that doesn't know anything about the case. We have people that just moved down from New York that don't know anything about the case. We have people from New Jersey or people that come in, and we have a huge population here in Jacksonville. So I can pick a fair panel in some cases, but do I try to move it? Oh, of course I try to move it. But that's such a small population, whether it's the jurors that know each other, whether it's the police officers, whether it's the victims, it just really shouldn't be tried there, is my humble opinion. Mm-hmm. But is it a distraction? Yes. Yes, I think it could be a distraction. Is it going to cause me concern at the end of the day of whether this case ultimately gets reversed for some reason? Yeah, that's a real possibility.
Wow. No one wants to go through this all over again. We're hoping things actually stay on course and work out. I want to talk about the fact that you said you tried 20 times to have a change of venue. It didn't work out. It happened once. You were telling me earlier back in 1998 with Maddie Clifton. Give us the circumstances why it actually was feasible that time.
Well, it's a very good question. And the irony is the judge did it on his own. It wasn't even the defense lawyer who made the motion to change venue. Judge Chuck Arnold made the decision that just based on all of the publicity, based on everything that was there, the judge did it on his own motion. He didn't even wait for the defense lawyer or the prosecutor to make a change of venue. Chuck Arnold, the judge at the time, who's retired now, he's the one who actually said, there's no way in the world we're going to get a fair trial here. And he moved it. It's the only time that in my 30 years of practicing law here that I've seen that happen.
Yeah. 30 years is a long time. You could definitely give us a lot of insight in this. Is there anything that you're seeing, because you're watching this closely like many of us, anything that you're seeing happening inside of the courtroom that is kind of standing out to you?
Well, Georgia's different than Florida. The way they break it down and the way they handle it is much different. In Jacksonville, for instance, we bring in 98 jurors. I mean, there's 7 rows of 7, so it's 49 on each side, and we go through that. Georgia does it differently. And so they break down and they go through the process they go through. And obviously there's a high profile case with a bunch of publicity. So they do it much different. So does that stand out to me? Yes, it's just a different style. Have I tried cases in Georgia? Yes. Are the juries and the jury selection process different? Yes. It's every state has their different way of doing things. And so is it unique to me? Practicing here in Jacksonville for 30 years? Yes. But do I understand their process? Yes, I understand their process. So I don't think that I've seen anything that's bizarre for Georgia. No, I mean, but it is definitely different than what you and I would see here in Jacksonville.
Yeah. There's a lot of things that are different this time around, but besides in this particular case, because now we have the pandemic playing a role in all of this. You mentioned the size of the courtroom and the number of jurors that can fit in there. 600 people were supposed to report on last week, Monday. They didn't get that number. I mean, obviously, everyone knew it wouldn't be that many. But what they had to do was move it to a community center nearby. They couldn't even bring them into the courthouse at that point, because there's a lot of different factors in this. But I do want to get back to that number of 1,000 jurors being summoned. Your thoughts on that?
That is unique.
Okay.
In all of the high profile cases that I've tried, I do not, 1,000 people, on a daily Monday morning in Jacksonville is probably extreme. It's probably extreme. Okay. I have had high profile cases where I've sat 98 people in the courtroom, and I've gone through and I made it to number 97. Okay. But that were not eligible to serve, but 98 was available. Okay. And so we were able to whittle it down. But then the judge told me that he had another 98 people in the city hall building waiting for their day to come up. So but now there were other courtrooms going on. There were other cases going on. So if there were 1,000 people just for this case, and that was the only trial, yeah, that's extreme. That's extreme. I've never had that happen.
Well, folks, if you are just now joining us, you're watching First Coast News' online coverage of the trial of 3 men charged with murder in the shooting death of Ahmaud Arbery. Ahmaud Arbery was shot and killed back in February of 2020 in the Satilla Shores neighborhood of Glynn County. And at this point now, fast forward to 2021, October of 2021, finally, these men are on trial for murder, for Ahmaud Arbery's killing. Joining us this morning is Richard Kurtz, a local attorney here in Jacksonville, not affiliated with this case, but he's giving us some insight as a trial attorney here in Jacksonville. Richard, you have touched on so many high-profile cases. We turn to you often for insight. You are here to give us some insight into things, because as novices, as outsiders looking in, we're kind of thinking to ourselves, how will it be possible to seat an impartial jury in this case? Glynn County is so small, and a lot of the people being questioned, a lot of the jurors that we saw have moved on through. Right now, the number stands at 47. 47 potential jurors have been chosen so far. Many of them raised their hands when asked if they knew certain key players within this case. How can we move forward fairly?
Well, if anybody in the courtroom did not raise their hand, I'd be surprised. Okay. I mean, or they're just maybe not being honest with themselves, because that is such a small community. And everybody in the United States has heard of this case. Everybody from Georgia, Florida has heard of this case. Now, the question is ultimately what the judge is going to ask and what the prosecutors are going to ask is, can you set that aside? And have you made a decision already? Or can you still listen to the evidence? And that's the key, is that can you still listen to the evidence and set aside anything else? Or have you already decided he's guilty, or they're guilty, or no, that he's, he was a criminal or he was breaking into a house? If somebody already has a predisposition, then they're not eligible. So that's going to be the magic words that are going to have to be spoken is, yes, I've heard of it. Everybody's heard of it. Just like O.J. Simpson, everybody had heard of it. There was so many high profile cases around the nation. But the question ultimately is, can you set that aside and make a decision based on the evidence that you hear and the law that the judge instructs you? So those are the jurors that are going to make it if we get that far.
Yeah. We want to talk about where we stand at this point right now. 47 potential jurors have been chosen. Right now, the judge is aiming to get to 64. Of that pool of 64 potential jurors, they are aiming to get an impartial jury seated of 12 jurors with 4 alternates. Will that happen? I'm sure the family is hopeful that it will, the Arbery family, because they have waited quite some time right now to see these men finally get to trial. Joining us this morning is Richard Kurtz, a local attorney here in Jacksonville, and I want to talk about the pace of this jury selection process. You said it's highly important, but people need to understand. It feels as if it's going rather slowly. We're in week 2 right now, day 9, but you mentioned it is critical.
It is absolutely critical that everybody takes their time. Recall, this case didn't happen 30 days ago or 90 days ago. This case has been going on for quite a while. And there was a long investigation, and there was a great deal of things that went into it. And we have 3 different co-defendants. We have different, moving parts that are involved in this, which means not only is the judge going to ask questions, the prosecutor's going to ask questions, and then there's going to be 3 different defense lawyers that are going to stand up and ask questions. So this is just going to take some time, especially if you summons 1,000 people and you're whittling it down. Common sense is going to say this is going to take a few minutes. Okay, this is not going to happen in one day. Mm-hmm. So, and jury selection is the most critical part of any trial. I mean, it truly is, because if you don't have a fair and impartial jury to start with, then where are you going with this case? So you have to have a jury that each side believes is going to be fair and impartial. If you don't, then you're wasting your time. You're preaching to the choir instead of or the pelicans. So I personally think this is the most important part, and everybody should be patient. And I think the family should be patient because they don't want to do this again. And if you don't sit the right jury, then you're going to have a problem later on an appeal, because everybody knows the story of appeals and why cases drag on. So I personally believe this portion of the trial is probably the most important portion of this trial that's going to take place. I suspect the trial itself will be half the time of jury selection.
That's interesting. You've been down this road before, so we'll take your word for it. I also want to talk with you about the timeline moving forward. They were aiming for 2 weeks for the jury selection. Obviously, that's not going to happen. We're at 47. They want 64 before even getting to whittle things down to the 12 jurors, 4 alternates. Your thoughts on when we will actually get to that point? We were saying maybe Tuesday, Wednesday. What are you thinking?
Yeah, I'm thinking Tuesday, Wednesday. I think we're going to get through today with jury selection. I think everybody's going to kind of, if it were me, here's what I would think would happen, is that we're going to get through today. We're going to whittle away at some more jurors. And then what's going to happen at the end of today is everybody's going to kind of like go, let's regroup, let's think, let's evaluate, and let's think about it over the weekend and come back. And if anybody has any additional objections, what we call back strikes. Is I didn't strike somebody. We put somebody on the 42 list or 47 or 64 list or whatever the number may be. And then we all go home at night and look at it over the weekend, and with your private investigators do all their social media research and investigation. And then we come back on Monday and go, oh, number 18, we have a problem. Number 36, we have a problem. And all of a sudden we start having conversation. So the other people that were not chosen into this small number, they're not going home. They're not going to be released from their subpoenas or their summonses. They're going to be on standby no matter what, because just because the judge says on Friday afternoon that we've got a panel does not mean we have a panel. So I would suspect Monday is going to be a regroup session.
Wow.
And probably Monday or Tuesday or Wednesday will actually be the opening statements.
Yeah, we're going to wrap this at 8:30, but before we do, I do want to go back a little bit, because if folks are just now joining us, you said something very interesting. As a trial attorney who's been down this road several times before, going into this, you would have done what? That case would not have been tried where it is for a reason. Tell us about that.
Absolutely should not be there. It's what we call a change of venue, and it absolutely should have been a change of venue. I personally would have had every news article, every news clip. I would have had everything filed into a motion that would probably be that thick, probably be 100. I've done it where I've had it almost 100 pages of showing all of the news articles, all of the, and then you go into the First Coast News where people, or what other, if there are other news stations, and you see what all the people post and all their opinions, and you track that, and you go with that, and then you put it all together and show the court that there's no way in the world we're going to get a fair trial here. And when you're in such a small community, the change of venue should have happened, even if they only moved it to Savannah. I mean, even if they just moved, I would have asked for Atlanta to move it because it's such a larger community, and there are more people that are going in and out of Atlanta. So I absolutely would have filed a motion for a change of venue and attached every news article that I could have possibly put out there. So a change of venue should have been granted, but judges don't like to do it because it's too expensive.
Right. And at this point, the odds of that happening in this case?
Not happening unless there's a mistrial. Okay, and just to briefly explain a mistrial, because there's 12 jurors and 4 alternates, and if they all make the 12 or one of this, whatever happens, it's going to be a verdict. But if one person does not agree to the verdict, whether it's guilty or not guilty, it's going to be a hung jury, and then they're going to start all over again. And at that point, I would 100% believe that it would be moved at that point if it was actually a hung jury.
Hoping that will not happen, though, at this point, right?
For the families, for
This
everybody.
is a lot for those families, both sides.
For the entire community,
yes.
And as I mentioned earlier, the law enforcement officers that are involved in this. I mean, people don't think about those, the first responders, those kind of folks. So, yeah, I think everybody hopes this is going to end whichever way it ends with justice for either side.
Yeah. Attorney Richard Kurtz, thank you so much for joining us this morning. Folks, you are watching First Coast News' online coverage of the trial of the murder trial of 3 men charged with killing Ahmaud Arbery. We're going to let you go right into court at this point. It's set to start at 8:30 as jury selection continues on this day 9, week 2 of this trial. Thank you again.
Thank you. Great seeing you.
turn everything off. No, this stays.
Yeah, but the mic.
Oh, I don't touch anything normally. It's I can do that.
morning. Good morning.
Good morning, everybody.
Good morning. Good morning.
Good morning. All right, I realize everybody's been here for a little bit. By way of introduction, I'm Judge Walmsley. I'm the individual that has called you all down here as potential jurors in the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. I want to thank you. I want to thank you for your service. I want to thank you for getting down here on a timely basis and joining us here in Superior Court. We can't do what we do in Superior Court with members, without members of our community, I should say, coming down and making themselves available. And I realize that jury service takes everybody out of their normal routine, and it's not something folks generally, and there may be a few that there are the exceptions to this, but generally folks don't look forward to coming down for jury service. I understand that. Particularly in a case such as the case that we're addressing here, which I understand there's a lot of information out in the community about.
That better? Okay. Where there's a lot of information out in the community that coming down for jury service because of the unknowns and everything else is not something folks are looking forward to. Again, I get that. But when I tell you we can't do this without you, I mean that. It is a very important part of the process, jury service, and hopefully by the end of the process here with us, you'll get a little bit of an appreciation for that. If you don't, that's fine. As far as jury service and jury selection in this case, what we're going to be doing today is relatively simple. What's going to occur is I'm going to swear you in as a panel. I'm going to ask you a few general questions, and then the state and the defendants are also going to have an opportunity to ask you questions. Now, those questions are not intended to make you feel uncomfortable. They're simply intended to determine whether or not you can be a fair, unbiased, impartial juror that will honestly seek the truth in this case and be able to reach a verdict in this case. Sounds simple. It is relatively simple, but it takes, at least what we've discovered with jury selection in this case, takes a little bit of time. And so as far as the timing of today, we're going to go through the day. What has occurred, or at least the schedule we've been keeping, has been that most of the panels have stayed through most of the afternoon. So as far as planning, please plan on being here for the day. With jury selection, how we do it is, again, questions will be asked. You will be referred to by number in this court. Those are the numbers that are on your chest. Now, the reason we do that, there's a couple reasons, but one of the reasons is that everything that you say and I say and the lawyers say is being taken down by the court reporter who's sitting over here to my left. At some point in the future, we may have to go back into the transcript to see who was talking, and it's easier to figure out who was talking by number than name. It's relatively simple. Because the court reporter is taking everything down, I need you to speak up when you're addressing the court or answering questions from the lawyers, okay? The acoustics in this room are pretty good, and there's not a lot of back and forth in this room, but particularly in the courtroom, I just need you to speak up so that we can hear you. And if we interrupt you because you're not speaking up, please don't be offended. It's just we need to be able to hear everything you say. The other reason that we're using numbers in this particular case is we are doing what we can during the jury selection process and really during the trial of the case to ensure that we keep the identity of the potential jurors and the jurors in this case private. And so, again, that's one of the reasons we're using numbers. We're also not pushing out any images of jurors. We're not pushing out any personal information of jurors. And part of the reason for that is because we want you to be candid in this process. We need you to be candid in this process. So again, we're doing what we can to protect identities and personal information so that you can feel more comfortable moving through this process with us. So again, the process is going to take a good chunk of the day. I appreciate your patience in that regard. You'll hear me say a number of times that I'm thanking you and I appreciate your patience. That may not come across as sincere, but it is. So please understand, it is on behalf of the Superior Court, you're here, and I appreciate the fact that you're willing to participate with us. So again, relatively simple process. I'm going to swear you in and ask you some questions, and then we're going to get started with the state first and then the defendants. So if I could please have you stand and raise your right hand. And if you could please respond appropriately. You shall give true answers to all questions as may be asked by the court or its authority, including all questions asked by the parties or their attorneys concerning your qualifications as jurors in the case of the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. So help you God. I do. All right, go ahead and have a seat. Ladies and gentlemen, again, this is the case of the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan, who are charged, each individually and as parties concerned in the commission of a crime by the grand jury of Glynn County with the offenses of murder, felony murder in 4 counts, aggravated assault in 2 counts, false imprisonment, and criminal attempt to commit a felony. I'm going to ask you a number of questions. First, please raise your hand if any of you are related by blood or marriage to Travis McMichael, Gregory McMichael, William R. Bryan, or Ahmaud Arbery. Please raise your hand if you, for any reason, have formed and expressed any opinion in regard to the guilt or innocence of the accused. Can't see the number, 272. Now, if you think you have, it's better to raise your hand if you've got a question, okay? Because we can follow up. 262, 263, and there's these glares that come off these cards. It's 543. And I had 2 down there. Is it, ma'am, all the way on the end, what is your number?
262 in the front row, far left, Your Honor.
Not 262, the behind. I thought there was a hand in the back.
272.
All right. Were you raising your hand? I couldn't tell. 272? Yes. You were. 273. 292. 294. And 298. Thank you. Please raise your hand if you have any prejudice or bias resting on your mind, either for or against the accused. $272, 273, 292. Thank you. And then finally, please raise your hands if your minds are not perfectly impartial between the state and the accused. I see no hand. Oh. 276. Better to err on the side of caution, right? Okay. All right, thank you, ladies and gentlemen. Those are all of the questions that the court intends to ask at this time. Is the state ready to proceed?
Yes, Judge, we are.
From the state.
Thank you. All right, good morning, ladies and gentlemen. Morning. All right, my name is Linda Dunikoski, and I, along with Larissa Olivier and Paul Camarillo, who will be joining us later, we represent the state in this case. We're the assistant district attorneys. Does anyone here believe they know me or Ms. Olivier? No cards. Is there anyone here who does not currently reside in Glynn County? No hands. Is there anyone here under the age of 18? No cards. And is there anyone here who has been convicted of a felony and not had your rights restored? No cards. Is there anyone here who sat on the grand jury that returned this indictment in June of 2020? No hands. Is there anyone here who is a post-certified law enforcement officer with arrest powers either locally in Georgia or federally? No hands. Is there anyone here who is 70 years of age or older who does not wish to serve on this jury? And we have 262. And we have 292? 294, thank you. Is there anyone here who is a full-time student currently enrolled in and attending classes? No hands. Is there anyone here who is the full-time caretaker of a child 6 years of age or younger, and you have no reasonable means of alternative care for that child? No hands. Is there anyone here who is a full-time caretaker of a disabled or elderly person, and you have no other reasonable means of care for that person? No hands. Is there anyone here who has difficulty understanding the English language? No hands. And is there anyone here who has difficulty hearing? No hands. All right, so ladies and gentlemen, we're going to start with a whole big set of questions, but the one thing I want to let you know is if you think it applies to you, raise your card. If you have a question about it, raise your card. If you're not sure, raise your card. The reason is we're doing general voir dire here that are kind of yes or no questions. But later, we're going to talk to you individually. So we're going to get the opportunity to actually, discuss with you what your issue is or what you have a question about, okay? And I'm also going to be talking about friends or family members. So when I say friends, I mean close personal friends that you have conversations with. And when I say close family members, I don't mean Uncle Bob in Iowa that you haven't talked to in 10 years. I'm talking about a close family member that you also talk to on a regular basis and have conversations with. So the first thing I want you guys to know is that we anticipate this case and the trial going through probably November 19th, which is the Friday before the week of Thanksgiving. So if you have a non-work related conflict, like a scheduling conflict or something that's a hardship that you want us to know about, we want to hear about that. And when I say hardship or scheduling conflict, I'm talking about you have heart surgery scheduled in 2 weeks. You have airline tickets to fly to Vermont for the birth of your first grandchild, and this is a big moment in your life and you've already paid for the tickets. Those are the kind of scheduling conflicts and things that we need to know about that's going on in your life from now through Thanksgiving. Does that apply to anyone? Please raise your hand. Wow, after that long speech, nobody. Oh, 282. All right, no one else. So does anybody here know your elected official, the district attorney for the Brunswick Judicial Circuit, Keith Higgins? Are you related to him by blood or marriage, or do you know Mr. Keith Higgins? No hands. Your former district attorney was Miss Jackie Johnson. Is there anyone here related by blood or marriage, or know Miss Jackie Johnson? No hands. Now, is there anybody here who has any particular opinion about last year's election where District Attorney Jackie Johnson was defeated and Keith Higgins became your elected district attorney? Anybody have an opinion about that election? No hands. Is there anyone who has an opinion about how or why the Cobb County District Attorney's Office was assigned to prosecute this case by Georgia's Attorney General? Does anyone have any opinion about that? No hands? All right, and is there anybody who's going to be unable to give the state a fair trial because we're from Cobb County, we're from Marietta, we're not from here, we don't live here? Is there anybody who's not going to be able to give the state a fair trial because we're just not from Glynn County? No cards. All right, so the Waycross Judicial Circuit District Attorney is George Barnhill. Does anybody know Mr. Barnhill personally or related to him by blood or marriage? No cards. Now, George Barnhill Jr., a former assistant district attorney in this judicial circuit, who now privately practices here in Brunswick. Does anybody know George Barnhill Jr.? No cards. The Atlantic Judicial Circuit, that district attorney is Tom Durden. Does anyone know Mr. Durden, related to him by blood or marriage? No cards. Does anyone here personally know any assistant district attorney, either here in the state of Georgia or somewhere else, like a prosecutor? No cards. All right, so we've talked about prosecutors. Criminal defense attorneys, we have Mr. Jason Sheffield and Mr. Robert Rubin. Does anyone know Mr. Sheffield or Mr. Rubin?
Morning.
No cards. We also have Miss Laura Hogue and Mr. Frank Hogue. Does anyone know the Hogues? No cards. And then we have Mr. Kevin Goff. Is there anyone here who knows Mr. Goff or has ever worked with Mr. Goff or hired Mr. Goff? No cards. Now, with regard to the defendants, does anyone here personally know Travis McMichael? Anyone here know Greg McMichael? Is there anyone here who knows Mr. William, he goes by the nickname Roddie, Bryan? No cards. Is there anyone here who knows a Miss Amy Elrod? And we have juror 293. Is there anyone here who knows Lee McMichael, Greg McMichael's wife? Oh, for Amy Elrod? Oh, I'm sorry, so 291, thank you. Feel free to shout it out. You got to get my attention, okay? I don't mind. So 291 for Miss Amy Elrod. Thank you very much. So let's go ahead and go back now. Lee McMichael? Anyone know Lee McMichael? Anyone know Lindsay McMichael, Travis McMichael's sister, Greg McMichael's daughter? No hands. Now, the victim in this case is Mr. Ahmaud Arbery. Does anyone here personally know Mr. Ahmaud Arbery? 275. Is there anyone here who knows his mother personally, Miss Wanda Cooper Jones? No cards. Does anyone know his father, Marcus Arbery Sr.? 275. All right. And does it, oh, and 262, thank you. Anyone else? Now, does anyone here know Judge, oh, and one more, 298? You know Mr. Marcus Arbery Sr.? Great. And yeah, bring it to my attention. Let me know. Anyone else? All right. Does anyone here know Judge Walmsley? No cards. All right, so we're going to talk about jury service now. Is there anyone here who has gone through this entire process? What I mean by that is you went through voir dire, which is jury selection. You were selected. You sat on the jury. You heard all the evidence. You went in the back and deliberated with the 11 other people, and you reached a verdict. Did anyone here go through that entire process? And we have 543. Anyone else? Okay, so juror 543, were you the foreperson?
Wait, are you talking in general or just for
No, for that trial.
which trial?
How many trials did you have to sit on?
Okay, yeah, and Chicago was the foreperson.
You were the foreperson. And okay, so in Chicago. How many trials have you sat on?
One.
Just the one in Chicago. Okay. And without telling me what the verdict was or what it was about, was your jury able to reach a verdict? Okay. Anyone else? No. Has anyone here ever sat on a grand jury? No hands. Now, when you guys got your jury summons, you kind of were directed to the clerk's website, and it had some information about the days to come and all that sort of information. It had COVID information there as well. But it also had some links to this case with some court documents. It's okay if you looked at them because they were there, okay, for you to look at those links, but we just need to know if you did or not. And they would have been like court documents, like you would have seen, you know, something versus something, the indictment. They would have been, you know, boring legal documents. Did anybody look at those? And it's okay if you did. So 543, 272, and 293. Anyone else? Okay. Please raise your card if you've served in the military. 275. And you know what? If you want to unclip it, you can unclip it and just raise it up and wave it at me. That's fine. If it makes you guys more comfortable, I'll be able to see you. You can unclip and wave. Is there anybody here with prior law enforcement training or law enforcement experience? So you may not be post-certified with arrest powers now, but you previously were. No cards. Does anyone here have a close personal friend or family member who is in law enforcement? I'm going to try and go in order here. We have 272. That's fine. See, you did the right thing. You raised your card. Perfect. 543, 263, 273, 276, 278, and 282, 292, 298. Right. Please raise your card or your hand if you have prior experience, work experience in the field of social work. No cards. Please raise your card if you have prior work experience in the field of counseling, psychology, psychiatry, if you have that as your undergraduate degree or you've been a counselor before. No cards. Please raise your hand or your card if you have prior work experience in the legal field. You're a lawyer. You have been a paralegal. You've been a legal assistant. Anything along the lines in the legal field. And we have 294. Please raise your hand or card if you have prior experience in the criminal justice system. And that can be you've worked at a prison or a jail, you have worked in probation, you have gone to prisons as a counselor, a minister, anything along the lines where you've worked within the criminal justice system. 294. Are you related to or do you have a close personal friend who actually works within a district attorney's office either here or anywhere else? No cards. Is there anyone here with medical training? And I don't mean you were a lifeguard or you have CPR. I mean like medical training, like undergrad degree, you've taken courses, it was your job. 294. Is there anyone here who's related by blood or marriage or has a close personal relationship with a criminal defense attorney? Is there anyone here who's ever had a bad experience with law enforcement? No cards. Anybody here have a good experience with law enforcement, such that it sticks out in your mind? No cards. Is there anyone here who's had a bad experience with a prosecutor? No cards. Anyone here have a bad experience with a criminal defense attorney? No cards. All right, so what we're going to do now is we're going to talk about convictions, sort of arrests, prosecutions, convictions, that kind of thing. So I'm going to first ask you about crimes like DUI to something more serious, okay? So think about in terms of DUI, shoplifting, up to something more serious, not traffic tickets, not that sort of thing. So have you personally ever been arrested, convicted, or prosecuted for something like a DUI to something more serious? No cards. Do you have a close personal friend or family member who has been arrested, convicted, prosecuted for DUI to something more serious? And we have 262, 273. Okay, great. That was the right thing to raise your card. And we've got 275, 278, 292, 293, 294, and 298. Is there anyone here who feels that they've been ever falsely accused of a crime, whether it involved the police or not? Do you have any friends or family members who you think have been falsely accused of a crime, whether it involved the police or not? No hands for either question. All right, so we're going to talk about being the victim of a crime, being the victim of a crime. Has anyone here ever been the victim of a violent crime or a crime against their person, like an assault, armed robbery, or something like that's a violent crime, a crime against their person? 273, 292. Is there anyone here who has a close personal friend or family member that has been the victim of a crime against their person? No hands. Oh, I'm sorry, 26. Sure thing. We're looking for people who may know a friend or a family member who've had a crime against their person. So that could be anything from being robbed. It could also mean like you were taking your shopping cart and somebody grabbed your purse and knocked you down. It could be anything you consider to be a crime against your person, whether it's kind of violent or not. But also if there was a violent crime, such as, an assault. 262. 278. Is there anyone else I missed? Okay. Right, friend or family member, so 272. So is there anyone here who's ever witnessed a crime in progress? 273.
I witnessed an arrest being made, and it was him. I don't know if he was doing the crime there, if he was being arrested for it. I just remember that.
That was the right thing. That's a good one. Okay. And 278. Has anyone ever taken cell phone video of an incident or crime or arrest that's going on? No hands. All right, so we're going to talk about burglaries and home invasions. Burglaries, you came home and your stuff was gone. Home invasion, you are home and someone kicks the door in, or you wake up in the middle of the night and someone's in your house. So has anyone here, you, family member, close personal friend, been the victim of either a burglary or a home invasion? We've got 274, 275, 292, 293, 294, and 298. Is there anyone here, you yourself, close family member, close personal friend, who has had a firearm stolen out of your house or your car? And it could be any kind of firearm, but it's been stolen out of your house or your car. 274, 292, 293. Is there anyone here who's ever had to call 911 to report a crime? I'm not talking about medical emergencies or anything like that. I'm talking you've called 911 to report a crime. 262, 274, 276, 292, 293. Is there anyone here who's ever given a formal statement to law enforcement? I'm not talking about that, fender bender, you're standing by the side of the road telling the officer about that. I'm talking about you've had to give a formal statement about a crime to a law enforcement officer. All right, so I've got 274. Go ahead, keep them up for me until I call your number, please. So 274, that's great. 277, thank you. 281, 281. Who else got 292 and 293? Did I miss anyone? Great. Is there anyone here who's ever had to be a witness at trial? And that means you're in the little chair in the witness box. You've had to raise your hand. Usually there's a judge. Sometimes there might have been a jury. Civil or criminal, doesn't matter. But at a trial, you've had to be a witness and testify. 278. Please raise your hand if you've ever taken it upon yourself to investigate a crime. No cards. Do you know anybody who's ever taken it upon themselves in a non-law enforcement capacity to investigate a crime? 262. All right, so ladies and gentlemen, I'm going to ask you kind of a big, broad question. So let me go through it all and I'll get to it. First off, take a look around. Do any of you recognize each other? That's the first question. Anybody know anybody else here? I know it's hard. We all have masks on. So raise your card if you think you do. 272. All right. And all right. Usually we got two people who recognize each other, but I'm not sure. But that's okay. Now, when you were over at Selden Park last Monday, you were there and you probably saw some people, right? Recognized a few people? What I'm asking is this. That other person that you saw, if you were selected to be on the jury and they were on the jury, would it be a problem for you? Like, as in, Your son was over at Selden Park as well. Your boss was over at Selden Park. Someone who works and reports to you was over at Selden Park. So it might be a problem if you were both on this jury. So if that applies to you, please raise your card. 298 and 273. Anyone else? All right. There's a reverse question. Is there anyone here who does not own any type of firearm and there is no firearm in your household? 543, 276. Sure, you don't personally own a firearm and there are no firearms in your household. 262, 281. Gotcha, 281, 291, and 298. Is there anyone here who's ever had to carry a gun as part of their job? No hands? Is there anyone here who's ever taken it upon themselves to get firearms training? No cards. Please raise your hand if you've lived in Glynn County for less than 5 years. 543, 281, 291, and 294. Is there anyone here who currently resides in the Satilla Shores neighborhood? Is there anyone here who previously resided in the Satilla Shores neighborhood? Is there anyone here who may be particularly familiar with this location, Satilla Shores, because you've got friends, family members, you go there, that kind of thing? So we have 262, 273, 293, and 294. Another neighborhood, Royal Oaks. Is there anybody here who currently resides in Royal Oaks? Is there anyone here who previously resided in Royal Oaks? Is there anyone here especially familiar with Royal Oaks because you have friends or family members that do reside there?
Is that part of work too? If you have to go to that location a lot for your job?
Sure, we'll go ahead and take that because you're familiar with it based on that. So 293, anyone else? 272. Yeah, any reason you might be especially familiar with these neighborhoods, and it can be friends, family, or work related. 262. For Royal Oaks? It's off Highway 17 at exit 29. No, okay. Is there someone else? 298, you know Satilla Shores or Royal Oaks? Royal Oaks. And 274, did you have your hand up? Okay. That's okay. All right. Is there
You're allowed to do that also.
Yes. All right. Is there anyone here who's familiar with the Fancy Bluff neighborhood, which is across from Royal Oaks over across 17? So familiar with Fancy Bluff. We've got 262, 275, 293, and 298. Is there anyone here currently living in Fancy Bluff? Anyone who previously lived in Fancy Bluff? No cards. All right, so this is a question about you knowing yourself. Is there anyone here who has a religious, moral, or ethical conviction that would keep you from deliberating with others and rendering a verdict in this case? And what that basically means, 262, right out of the gate. So what that can mean is, if you're selected, we decide to put you on the jury, and you go in the back, you're never going to render a verdict of guilty, not guilty, because that's all you're going to be asked to do is guilty, not guilty. Is there anybody here because of a religious, moral, or ethical conviction that would not be able to deliberate with others and render a verdict? 263, 276, 2... Sure. Juror 262 is asking if this is a death penalty case.
As jurors, first of all, it is not up to the jurors to determine any punishment in any case and under the circumstances here. And the answer to your question is no. And it shouldn't affect any of the answers here today, but just to answer that question, no, if that was weighing upon your mind.
So, and I want to make sure, now that you know that, we have, are there religious, moral, ethical convictions that would keep you from passing judgment on another person to render a guilty or not guilty verdict and deliberate? Does that apply to everyone still? So go ahead, raise your cards for me again so I make sure I get everybody. No, not for you, you're putting it down. All right, so 262, we're taking you off. 263. 276 has her card down now. And 298, that still applies to you, ma'am. Okay, so 298. And 272, it still applies to you? Okay. Is there anyone here who does not belong to a religious, fraternal, or social organization? What I mean by that is you don't go to church, synagogue, or mosque. You do not belong to the bowling league, a bridge club, a book club. You do not belong to any professional organizations in regard to your profession. Like if you were in marketing, you don't belong to the American Marketing Association. You just don't belong to any sort of those groups. Is there anyone here that applies to? 276 and 291, 292. Please raise your hand if you, a relative, or a very close personal friend has ever been arrested and the circumstances were such that you thought they were treated unfairly by the police or the criminal justice system. 273, 298. Please raise your hand if you have a friend or family member who's been arrested and or convicted for kidnapping or false imprisonment. No cards. Please raise your hand if you, a relative, or a close personal friend has ever been arrested for shooting someone or shooting at someone. No cards. Is there anyone here who has a relative or a close personal friend who's been arrested and or convicted for the crime of murder? No cards. Oh, 292. Thank you. 292. All right, is there anyone here who feels that they're not going to be able to follow the law if they disagree with the law or think that the law should be something else? Judge Walmsley's going to give you the law, but we're trying to find out if you're somebody who's just not going to follow the law, if you disagree with it or think it should be something else. Does that apply to anyone? No cards. And is there anyone here who wants to serve on this jury? No cards. All right, ladies and gentlemen, we're going to do this next part. You're going to have to bear with me, okay? The next part involves potential witnesses that would be at trial, okay? And so I'm going to read off the list in a couple sections. I'm going to try and go expeditiously, but you've got to call out, like get my attention, start waving me down if I go past. All right? So the first group of people we're going to do is we're going to do some Glynn County law enforcement officers. These are police officers from Glynn County. William Duggan, Sheila Ramos, Chris Lowther, Ricky Shane, 292, knows Lowther. Ricky Shane Minshew, Jeffrey Brandenberry, Parker Marcy, Brad Butler, Caitlin Roberts Phillips, Roderick Nohilly, Adam Jackson, Stephen Lowry, Brandon Gregory, Diana Bibby, Sherry Bashler, Chris Hatcher, Robert Rash, Officer Powers, Officer Stansberry, Officer Owens, Ronald Cooper. We have Ronald Cooper, 293. And then we have with the Glynn County Sheriff's Office, Detective Stephanie Herndon Britt, 293 and 277. All right, I'm now going to go ahead and go through the Georgia Bureau of Investigation. Now, there's two parts to the Georgia Bureau of Investigation. There are special agents, which just mean they're detectives, and then we've got the other side, which is the crime lab. So does anyone here know GBI agent Jason Seacrest, Jessica Hamilton, Lawrence Kelly, Bryan Smith, Richard Dial, Garrett Morton, Matthew Heath, Amanda Barker, Jennifer Woodward. No hands. And then with the crime lab, James Jim Gordon, Amanda Cook, Jesse Worley, Ann Kistler Rao, Brian Leopard, Dr. Edmund, Brian Leopard, 272. Anyone else know Mr. Leopard? And then Dr. Edmund Donahue. All right, these are non-law enforcement folks. Joe Mandela, Joseph Allen Bartlett, Subi Lawrence, Annabelle Beasley, Christy Barber, Matthew Albenzi, John Ronald Olson, goes by Ronnie Olson, Diego Perez, his wife Brooke Perez. Does anyone here know, for the Glynn County 911 Operations Division, Kara Richardson, Jamie Dunwoody? All right. We also have non-law enforcement, Mr. Larry English, Amy English, Kelly Parr, or her father Randall Parr, Daniel Alcott, Christine Alcott, Judith Alcott, Kim Ballesteros, Carol Flowers, Lauren Bennett, Linda Randall, Ashley Wittenberg, Danielle Stoddard, Cynthia Drummond, James Trimmings, 275. Catherine Miles, Cody Johannes, Derek Thomas, Hillary Lauren Brady Germano, Josh McGowan, Kyle Meisner, Nicole Lee Joyner, Rusty Russ Wayne Johnson, Zach Langford, 293, you know Zach Langford? You know Ashley Langford? No? No. Zach only. Heaven Bryan, 277. Peyton Thompson. Did I miss anyone? All right, ladies and gentlemen, thank you very much. I'm going to hand you over to the defense. They have some questions for you as well.
Mr. Sheffield.
Yes, sir. Good morning, everybody. Thank you also from all of us for being here. Point of order. We have read the forms that you have filled out and really appreciate all the honesty and the length that you have gone to be candid in those forms and in those answers. Nothing that you have said is going to hurt our feelings. It's not going to make it uncomfortable for us. And we just want you to understand over the last week and a half, we've heard a lot of additional, very honest answers in the sessions that we've had one-on-one with jurors. So we invite you to be honest. You will not be judged in any kind of a negative way. We thank you in advance for that. I have about 15 minutes worth of questions that'll go pretty quickly. Now that you've sat here for about an hour, I want to place Travis McMichael for you, formerly in the Coast Guard, formerly working for Metson Marine. If that puts a place on a name or a face, does anybody recognize him now that I've added those facts? Okay. How about his dad, Greg McMichael? Now that we've sat here for a minute, anybody recognize Greg or feel like there may be an association? No? Okay. And then also Mr. Roddie Bryan. You're welcome to stand up and come around if you can't see. I see a hand for 293.
Hey, recognize me?
Yes, sir.
Yes, sir, I recognize him.
Okay. All right. We'll drill down on that later. Very good. Thank you. 293. And 263. And 277. You're going to notice that I'm going to go real slow and I'm going to go row by row when you raise your hands, okay? Okay. There's been a lot of talk about this case, a lot of articles, a lot of news. As you have listened to all that before you've come here today, have any of you developed a negative opinion about Travis McMichael or Greg McMichael or Roddie Bryan? If you have developed a negative opinion, whatever that means to you, just raise your hand. 262. And once I call your number, you're welcome to put it down. 263. 543. 272. 273. 274. 275. 276. 277. 278. 279. 282. 292. 294. And 298. Very good. Thank you. So we, criminal defense attorneys, represent those who are accused of crimes. Do any of you have any negative thoughts or feelings about criminal defense lawyers for doing the type of work that we do? It's okay if you have a negative feeling about us, but none of you do. Excellent. Thank you. Have any of you ever decided to vote for or support a political candidate who had as part of their platform to limit gun rights in any way, whether the types of guns that can be carried or that guns should be carried, supported a political candidate who had as part of their platform? Okay, very good. Do any of you sitting here now oppose laws, disagree with the laws that allow people to carry firearms, either openly or concealed, into public? You don't like those laws, you oppose them. Just raise your hand if you feel that way. 274 and 294. There's been a lot of participation in marches around town on the social justice movement. Have any of you participated in any of the demonstrations or marches around town? either before or after the shooting and death in this case. If you've gone out to listen or support or march or walk or whatever it is, please raise your hand. 298. Thank you. If any of you have supported in any way the Black Lives Matter movement, a movement that's not only local but national, or if you have supported the Justice for Ahmaud movement or the hashtag #IRunWithMaud, whether that be a bumper sticker, a sign in the yard, or through social media, Facebook posts, reposting things that people send to you, anything that deals with that type of support, please raise your hand. 272, 273, 275, 292, and 298. Thank you. Please raise your card if you feel that you have ever been denied an opportunity because of your ethnicity or your race. If you feel like anybody has ever denied you any opportunity for one of those reasons. Yes, ma'am. 262 and 298. If you feel like you've ever been falsely accused or placed under suspicion for doing something wrong because of your ethnicity or your race, please raise your card. 272 and 298. Thank you. Do you agree with this statement? The old Georgia state flag, the one that flew from 1956 to 2002, was a racist symbol. It was taken out of circulation in 2002 because a lot of people held that belief. Does anybody here feel that way? Okay, 272. Thank you. Do you agree with this statement? People of color are not treated fairly in the criminal justice system. 262, 272, 273, 274, 275, 279, 277, 292, 298. Do you agree with this statement? Police in this country do not treat black folks and white folks equally. Police in this country, whether that be because you had an experience with it or just because that's how you feel locally, statewide, or nationally. 262. Yeah, it's a comment on the police and whether or not you feel that police treat black folks and white folks equally. Is there something about policing where you feel like it's not equal treatment, people of color and white people? Where did I leave off? 26, maybe I just, all right, 272, sorry, 273, 274, 275, 278, 279, 292, 294, and 298. Thank you. Who feels that a psychologist or a psychiatrist could diagnose just about anybody with a mental illness these days? It's a comment on the field of psychiatry. Pretty much anybody gets diagnosed with a mental illness these days. 277. 294. Thank you. Please raise your card if you have an opinion about the lapse of time between the incident date in this case of February 23rd, 2020, and then the arrest date several months later in May of 2020. If you have an opinion about that lapse of time, please raise your card. 262, 272, 275, 277, 279, 292, 294, and 298. Thank you. We want to make sure that we have your full attention should you be selected for the trial of this case. The trial will go on daily from probably 8:30 or 9 o'clock in the morning until dinner time. There'll be a morning break, an afternoon break, and lunch break. But we want your attention while we're presenting evidence to you. Does anybody fear that something going on at work or at home will cause them to be divided, that we will not have your full attention because something is going on in your life at work or at home that would prevent you from giving us your full attention at all times? 263, 546. Yeah, sorry, it was a glare. 272, 279, 292, and 298. Similarly, as it relates to your attention and whether your attention will be impaired, is there a mental issue that you have, a psychological issue that you're working through, or a physical ailment or hearing impairment or visual impairment that could affect your ability to pay attention for the periods of time that we're in court? Please raise your card if you have one of those things. 263, 272, 273, 276, 278, 279, 294, and 298. Ultimately, if you're selected, you'll participate in deliberation with 11 other jurors, and you'll hopefully come to a decision about this case. But we want to know if there's anything about you coming to a decision, no matter what it is, not guilty or guilty, that you feel you won't be able to do because of what might happen to you in the community after this case is over. That you have a concern about your involvement on the jury and rendering a decision in this case, and that concern relates to what might happen after this case is over. Raise your card. 263 and 272. And lastly, we know you filled these forms out quite a while ago. It could have been several weeks, maybe. If you now thinking back, whether it's one of your social media names or handles or any of the information that you filled out has changed, you have new accounts or you have new thoughts or feelings about it that are not currently reflected on the form, we don't want to hold you to the form if something has changed. So if there's been any changes to the forms, please raise your hand and we can follow up about what those things might be, even if you've changed your social media address. No changes. Okay. Very good. Thank you, Your Honor. Thank you all very much.
All right, thank you, counsel. Ladies and gentlemen, what we're going to do at this point is we're going to take a 10-minute recess. And during that recess, I'm going to ask that you step out of the jury assembly room. During the recess, do not discuss this case amongst yourselves or with anybody else. Don't go looking for any information about the case. And if anybody tries to talk to you about the case or is talking about the case in your presence of hearing, please notify the court and we'll go ahead and get that addressed. So again, don't get on the phone and start reaching out to spouses, friends, family, or anybody else and talking about the case or the process. Don't go looking at your news feeds or anything having to do with media coverage or anything about the case. And again, if somebody approaches you about the case, let us know. So the way the process is going to work at this point is you're going to come back into this jury assembly room. We will have moved into the courtroom, and then based on your responses to the questions here, there may be some follow-up with each of you individually. And we'll work through that as quickly as possible. Again, I do appreciate your patience with regard to the process, and I thank you for being here. So we'll take a 10-minute recess. We'll see some of you back in the courtroom in just a little bit. is how close the juror is as compared to many others with, in this particular instance, Mr. Arbery. He's indicated it can be fair, and I truly believe he thinks that. The issue for the court is, given the closeness and some of the ways that he was referring to Mr. Arbery in this instance, indicates that he did have a personal connection, and I'm concerned about that. Now, if the defense wants to talk to him about that, that's fine, but before we spent 40 minutes or so talking about it and talking about everything, I wanted to point that out to counsel, that was a significant concern of mine before we got too much further down the track. So that's what I was doing.
I'll move to excuse him for cause then right now.
If we may have just one moment.
Go ahead.
There's no objection from the state, Your Honor.
All right, and just so that we're clear, because I don't want the court to be misconstrued, he talked about how he was friends with Marcus Arbery. I got the distinct impression from his answers that he was actually possibly closer to Ahmaud Arbery. And the part that got me was, if he saw Ahmaud, he would give him a hug or something, and kids considered him a friend. And that's a closeness that the court would have real concerns about. And for the record, again, I do not believe he in any way was not candid with the court. In fact, I think he was candid enough with the court so that we could flesh that out. So that motion is granted. 275 is struck for cause.
We have a short break.
Yeah, well, probably a good time to break for lunch anyway. Let's go ahead and we'll break for lunch. Let's do an hour. It's 11:43. We'll come back at 12:45 and continue with jury selection at that time. Thank you, everybody.
Thank you.
to finish or complete his jury service if he was to be picked on this jury, based on what he's just now telling us.
The state asks that you deny that. This juror has had this issue going on for weeks and has gone to work without a problem, despite his testimony or statement that, well, it happens at work and I sit down. He hasn't bothered to go see a doctor if it was weighing on him that heavily and it was such a concern. And this is a stressful situation. We're asking him a bunch of personal questions right here. In fact, I think a couple of jurors this morning said, my heart's about to beat out of my chest. So this is a very stressful situation, and he said he was a bit jumpy right now. During trial, he's going to be sitting here having evidence presented to him, and we know we're going to take breaks, and we know that the court is considerate of people who may need to use the bathroom or get up and walk around. So at this time, it does not appear that his health issues are such that it would keep him from serving as a juror in this case. We ask that you deny the motion.
Your Honor, I have to be heard. Your Honor, I'm deeply concerned about this juror. I'm concerned about his health. If 20,000 protesters show up for the first day of trial, I don't care how you're getting to the courthouse, he's going to freak out. Matter of fact, we might just kill him. I think it's incredibly reckless, and I'll take that back. I think it's unwise to ask this juror to potentially put their life in jeopardy. Now, we could all argue maybe he should have gone to the doctor. Maybe, Your Honor, given that he's probably close to a minimum wage employee, maybe he can't afford to go to a doctor. And I'm also concerned that I'm familiar with his business. And anybody who wants to roust him during this trial, it won't take much effort to do it. And then we might not have to decide whether his health's in jeopardy. It might already be decided. He could have a heart attack just going about his personal affairs during the trial. This is a huge liability for the completion of this case. We got 900 million jurors out there waiting to be heard from. There's no reason to put this gentleman through this.
The court's granting the motion, but it's in addition to the health issues. So the health issues are a bit of a concern to the court, but the state does make a point that he is here. The concern is weighing on his mind, and that is a bit of a concern to the court also, although he did indicate that he did say that what I'll just call the magic words, that his opinion is not fixed. He indicated it would take overwhelming evidence to change his mind in this case. He also said he'd have a hard time, that his mind was, it was clear to me that this was not the right thing. I would have a hard time with the evidence against that. Although his opinion is not fixed, it would take overwhelming evidence to change his mind. He then talked about how he would hold the state to his burden. But then in addition to the health issue and that, he starts talking about this, I'll just call it a friend of a friend. Although they haven't discussed the case, obviously that is a very important relationship to him. And I didn't get his exact language, but it adds a layer which results in him being pulled in that direction, means towards a guilty verdict, because he said in favor of Ahmaud, so he made it very personal, in favor of the victim, or the purported, I'll just use that term here. But it may ruin my friendship depending on the outcome, and he said twice, I don't want that to happen. Based on all of that, the motion's granted. 278 struck for cause. $279. 279. express any motions on this panel as well as panel one. Are we prepared to do that, or does everybody need a moment to take a look at what they have?
Skate's ready.
We are ready. If you give me 1 minute to grab it.
On panel one, you say?
No, both. This one and panel one.
Okay. We're doing panel one.
No, we'll do this panel first, and then panel one. Go in the back. We lost one. About to lose two.
All right, we're back on. Defendants are in court, represented by counsel. Understand we're ready to go ahead and proceed. Off of panel 7, 262 was struck for cause. 263 was struck for cause. 543 was struck for cause. 268 and 270 were rescheduled, and we will go ahead and address them hopefully on another panel. 272 struck for cause. 273 struck for cause. Gets us to 274.
No motion from the state.
No motion from the McMichaels.
No motion from Mr. Bryan.
274 is qualified. 275 was struck for cause. Gets us to 276.
No motion from the state.
No motion from the McMichaels.
No motion from Mr. Bryan.
276 is qualified. 277 was struck for cause. 278 was struck for cause. 279 was struck for cause. Gets us to 281.
No motion from the state.
No motion from the McMichaels.
No motion from Mr. Bryan.
281 is qualified. 282.
No motion from the state.
No motion from the McMichaels.
No motion from Mr. Bryan.
282 is qualified. 291.
No motion from the state.
No motion from the McMichaels.
No motion from Mr. Bryan.
291 is qualified. Off of that panel then, I have 274, 276, 281, 282, and 291. Does anyone have anything different?
That's what the state has.
That's what the defense has.
That's what we have. Yes, Your Honor.
All right, the first available juror I have on panel 1 is 773.
No motion from the state.
No motion from the McMichaels.
No motion from Mr. Bryan.
.773 is qualified. Number 1 I have, I'll just make sure. Yes, number 1 I have is struck for cause. Next available is juror number 2.
The state has a motion.
I believe we join that.
We join.
Juror number 2. Is struck for cause by consent. Juror number 3 has been struck. Juror number 4.
No motion from the state.
Motion for cause by the McMichaels.
All right. Motion?
Thank you, Your Honor. This juror originally raised her hand that she was not fair and impartial and that she had negative feelings towards the defendants. She then was questioned individually, and of course we were focused on a pretty emotional juror questionnaire that had to do with her opinions about, I'll just do snippets, I'm not cherry picking here, I'm just showing the things that were disturbing. She's characterized the chasing, that Arbery was jogging. She had the actual date there. She was pretty clear what she understood about chasing on foot and being shot. Arbery was trying to get away, and then they claimed she wrote self-defense. Arbery unarmed, jogger. Then the local police and the law took the defendant's word, self-defense, told Arbery's mother that he was killed during a burglary. Video of an event surfaced months later. The GBI took it over and charges were brought in May. She believed she knew a good bit about the case, and when questioned individually, she was asked about an incident where stuff had been taken from her sister and brother-in-law, and she found out that they had gone out, and she thought, oh my gosh, she was shocked that it was an event, that she was very emotional about it, that it was an event that she was shocked about because of anyone could have gotten hurt or something worse. But she said that that would not have an impact on the case. She was questioned about guns. She's not a fan of guns, she said, and that goes all the way back to her childhood. She talked about the prejudice that she might feel, and then whether she believed that prejudice and racism came into the case, and she said that is the big question. I have negative feelings about all three of them. And she said a man died, so yeah, I have a pretty negative feeling about all of it. But what was, as the inquiry went further, Your Honor, she was asked repeatedly, could you listen to the evidence and make a decision on the things you hear in the courtroom? And she continued to say this mantra, I hope so, I hope so. It's a hard thing, I would hope so. So with all of the questions that the state was asking originally, could you follow a defense of, or give meaningful consideration to a defense of citizen's arrest? And she said, it's hard to believe that there's a law. I don't understand citizen's arrest. But then she was asked, but if the judge told you you had to follow the law, would you follow the law and render a verdict solely on the evidence at trial? And she responded, I hope so. She further went on during the inquiry by the defense that yes, I formed and expressed an opinion. Arbery was hunted and chased down by two men in pickup trucks. They are guilty of killing him. I don't understand citizen's arrest. I was very disturbed by this, and I'm concerned that it took from February to May to get an arrest. She said that the sources of her information, she talked about the New York Times, and that's concerned her because she believed that was a reliable media. So for this reason, Your Honor, given the summary that she gave in such detail and with such emotion, as well as the answers that she gave that were full of emotion and the responses to her ability to follow the law and put aside those things to give an fair and impartial trial, always being equivocal. I don't have a single note where she answered anything that wasn't with an equivocal, I hope so, because it's a hard thing, I hope so. We move for cause.
No, we would join in that specifically. My notes show that I asked specifically about Mr. Bryan, and again, echoing what was said, she hoped she could be fair to Mr. Bryan. And that equivalency is reflected in the entire examination of this juror and compels, I believe, that she be excused for cause.
Thank you, Judge. Saying I hope so is no different than saying I will try. It's the exact same thing. And she did say I would hope so repeatedly. That seemed to be her way of telling all of us, I'm going to try. Numerous jurors have said, I will try, I can't guarantee it, and they have been impaneled as jurors, potential jurors. She described herself as a critical thinker, but she doesn't understand citizen's arrest. I had a note specifically, she was asked about Travis McMichael, negative impression, but only from the papers, and it was just a general impression. She was asked repeatedly, would she hope to render an opinion? No. She would hope to be able to render an opinion, even though she came in with an opinion, she would look at all the facts and the law, and for these reasons, she felt she could set her opinion aside and base it on that. In addition, let me find out where I put that. She did indicate she really didn't want to be on the jury, but she would hope to be fair and impartial, and she would follow the law. That's what I have. Thank you, Judge. We ask that you don't deny the motion.
All right. This is one of the first jurors that got into a really long examination and provided the court and the parties with significant information, and said a few things I think are important for a strike for cause. She did indicate that she was a critical thinker. The whole issue of citizen's arrest, what my notes indicate she didn't understand. She said that she didn't understand what citizen's arrest was. She will be instructed on that. If given the law, can you deliberate based on the law? I hope so. Again, this is whether or not she should be struck for cause, and that doesn't raise to it at that point. I don't think I know as much as I think I did after we started getting into the questioning in this case. Can set aside, that's a hard thing, I would hope so. With questioning by the defendants, again said she just didn't understand citizen's arrest, how that fits, and that's something that she'll be charged on, and depending on the evidence will be presented. Saw the video once and was disturbed by it, and there was some discussion about what that all means. She was asked that question, can you be a blank slate? And she didn't say that she wouldn't be. She seemed open based on my notes and the reaction. She was asked about negative views of Greg McMichael and talked about from what she understood, but that gets back just to the news and the video. And she even said, I don't know the details of that, again referencing the fact that she did not have all of the information she would need to make a full decision. Talked about how whether guilty or not guilty, people will be upset. That's not pushing her in one direction or another. And then she finished with this language of I hope so again, which she repeated throughout the questioning. And at some point close to the end, I believe it was, or maybe it was in the middle of the questioning, talked about how she was used to looking at things critically based upon her background in accounting and auditing. And based on that, the court is going to deny the motion and qualify juror number 4. And I think 5 may have been the last one we got to. So, juror number 5.
No motion from the state.
Motion from the defendants.
Go ahead.
You join.
Your Honor, the juror number 5 answered what do you believe the facts of this case to be on the questionnaire. A young black man had been jogging in a neighborhood where he had jogged before. On February 23rd, 2020, the McMichaels saw him retrieve their guns, claiming that Arbery was robbing properties and shot and killed him. During this encounter, Bryan was present and videotaped the shooting. During the panel discussion, she raised her hand to say that she had formed an opinion and expressed it, and she also indicated that she was a caretaker for someone who was elderly. So in that instance, she was questioned about both of those issues individually. Make sure something's not, one second, I want to make sure that I've lined this up. Yeah, but did I got the form? Yes, okay. So when she got to individual questioning, she was asked about the facts of the case. Where did you get the facts of the case? And she volunteered that she believes, or what do you believe the facts to be? And she said the truth. It's based on the news, the things I've heard, social media, newspapers, people in the community. It's national, it's everywhere. She's discussed it with all sorts of people. She said her parents, grocery store, football game. Asked further about when you said claiming that the defendants said that, yes, I have formed an opinion about guilt. It was based on all the facts and the things I have knowledge of. She said she does have a negative opinion of the defendants and indicated, I always think before I speak. She has negative feelings about what they have done. So here's where it got kind of oddly bogged down, and it may have been a product of it being the first panel. Can you set your opinions aside? She said yes, and this was the first time we began to inquire how. It was an objection, it was sustained. Can you erase the bias and prejudice that you have? Objection sustained. Do you see racism in this case? Yes. From what I know, she said, jogging, a man was jogging, he was unarmed, and he had run there many times. She was then asked, can you be fair if the issue of racism is part of this case? A question that we regularly ask now, but there was an objection, which was sustained. If the facts, so the questioner tried something else. If the facts indicate to you that the defendants are guilty, will you carry will you carry this opinion throughout the case no matter what you hear? It was an objection, and as my notes indicate that the court intervened at that point, and that actually that may be the question that you asked. Would you carry this opinion throughout the case no matter what you hear? So Mr. Goff came up, I believe, and was asked about, well, I shouldn't cover the part about Mr. Goff, but that, yes, she said, I have an opinion about the videotaping, and these are the words she used. It was disgusting, and it was vicious, as well as what took place. But I'm thankful that he did so we can see what happened. But it's still very sad. Her opinions are quite fixed, Your Honor. They've been fixed from the moment that she completed this questionnaire, and they remained that way throughout. What I think is different about this juror, who has stood by her opinions, even though she's answered the questions about whether she'll do what you're supposed to do in this courtroom, whether she answered those affirmatively, the difference here is that she believes, what she believes, she calls the truth of the case. Not as other potential jurors have indicated, which is, oh, I know what I've seen may not be actual or accurate. She said, I call this the truth of the case. And for that reason, and also respectfully, Your Honor, the fact that because this was earlier on and we were foreclosed from asking all the things that we had hoped to ask and that we are asking now, that we err on the side of caution and excuse this juror for cause.
Obviously, you aren't joining that. You know, we've heard from a lot of jurors who are all looking at basically the same social media. And typical juror responses, they don't know, some of them don't even know my client's name, don't know what his involvement is. They've all seen the video, don't seem to have any particular response to it. This juror not only says the video is disgusting, the way I read her body language is it's not the content of the video that's disgusting, but somehow she's disgusted that Mr. Bryan made the video, which I think, although we've heard that out in social media, this is the only juror to really make that point. I mean, this is a personal thing. That's the way it came across to me. A very personal thing with Mr. Bryan that's not based on the video itself. It's based on something else that's going on with her. And the only conclusion that I can draw, echoing co-counsel, not co-counsel, let's be clear about that, McMichael counsel, is that there's something else there. It's the truth. What happened is the truth in her eyes, and that makes Mr. Bryan disgusting because he took the video when the video itself doesn't provide any basis for that assumption of truth as to Mr. Bryan. Of all the jurors we've talked to, her reaction with respect to Mr. Bryan clearly stands out among everyone here. And when you combine that with her talk about the truth and her nonverbal communications, I think Mr. Bryan is certainly entitled to a strike for cause, whether the McMichael defendants are or not. Mr. Bryan is certainly entitled to it.
And Your Honor, I left one important piece out, and this was the question of hardship. I thought, couldn't find it, that we didn't explore it, but the state did. She has a 3-year-old daughter, she's the sole caretaker, asked whether she has other reasonable accommodations for the child, thank you. She said, I have an ex-husband, but he is not yet allowed to keep her, he doesn't keep her overnight yet. So there's some issue about, that we can imply, I suppose, assume that there's some safety issues or caretaking issues. But the child is at daycare while this woman is at work. She just would have to be able to pick the child up by 5:30. So it would be incumbent on the court to be willing to make sure that we were out of here in time for her to get this child, and that she has no other person to take care of the child.
Thank you, Judge. This was early on in the process. However, this juror, upon the questioning by the state, did indicate that she could be a fair and impartial juror, that she would put her opinion aside and base her verdict on the evidence. Her statement actually in her questionnaire is very neutral. It is a description, like as if you were writing an essay. It is not laden with value-laden words. A young black man had been jogging in a neighborhood where he had jogged before. That's actually true and will come out in evidence. On February 23rd, the McMichael saw him. That will come out in evidence. They retrieved their guns. That will come out in evidence. They're claiming that Arbery was robbing properties. That is their claim. And they shot and killed him. That's what happened. During this encounter, Bryan was present and videotaped the shooting. There's nothing value-laden with those words at all, and it was, what do you believe the facts of this case to be? So she did express that she could be fair and impartial, because I believe this is the juror where we objected to the kind of tone in cross-examination where, well, explain yourself, justify how you're going to be able to do that to us. And that's when the state objected to those sorts of questions and kind of went down that particular rabbit hole at that time. But she did indicate, I think before I speak, because I think someone asked her a question and she paused, and there was this long pause, and she explained, I think before I speak. So at this time, based on the fact that she did say she could be fair and impartial, we ask that you deny the motion for pause.
Okay. Yeah, she was asked specifically about her opinion in the case. She said, I have no opinion on guilt or innocence. She did talk about her 3-year-old daughter and no overnight visits. I'm a bit concerned about the daycare issue, but she has daycare coverage to 5:30. I, in fact, just had a status with everybody where the court's intent would be to stick to normal days, and I'm just not sure that's enough for the court to strike her. I'm just not sure that alone. Because she did say that she could serve as long as it went to that time. I'm not going to strike her on that basis. Now, the whole thing about facts and the truth, so I remember the question because it was an interesting response to the question. So she was asked about the facts of the case, and she referred to them as the truths, but then there was a questioning about whether those truths or facts were fixed. And there was then a discussion about how she'd gotten that information from news and social media. It was just what she had read or heard. And then she added that, obviously, I was not present, which qualifies that. So the whole question about what the truths are, I think, is well qualified in the record. She did not indicate that she had a fixed opinion. She was asked a question about, are you not impartial? And it's kind of confusing. I think there was some confusion there. She was asked about whether she could set things aside, and she said yes, and we did then get in the back and forth. She did respond to the racism issue, but I didn't hear any questions about whether she would not consider the evidence in the way that she had indicated earlier in the questioning. And then there was the question from Mr. Goff about the videotaping. My notes are that the videotaping scene was disgusting. Now, that could be interpreted a lot of different ways. But what she also did say was that thankfully he, being Mr. Bryan, did videotape because we were able to see what happened, which means that in a way it ends up being a positive, but more importantly to the court, and I wrote a separate note next to this, there's no indication that she would not be willing to listen to the evidence and consider the videotape in whatever way it was approached by counsel. Based on all of that, the court's not going to strike her for cause. I do have some reservations, though, about the timing with the daycare, but 5:30 is well into the afternoon.
And I'm probably not saying anything the court hasn't already pondered on the daycare issue. I think this is the practical issue. In a normal felony jury trial, it was 2 or 3 days. Probably not an issue. Given the anticipated length of this trial, the odds are probably better than 50-50 that the child is going to get sick during the day, throw up, some student's going to do something, and she's going to have to leave during the middle of the day to deal with her child. And just given the length of the trial and children, for a trial of this length, if she doesn't have someone else, and she's indicated she doesn't at this point, then we're going to end up taking recesses during the trial for her to deal with child care issues. And with all due respect, I don't think anybody really wants to go there, even the state.
Your Honor, I was just looking this up, but trying to see if an individual wants to avail herself, as she did, raising her hand. Raise your hand if you have a child under the age of 6. You're the sole caretaker, got both of those, and no other reasonable accommodations for caring for that child. And she indicates, I'm all 3 of those. I've got care for the child during this limited amount of time, but especially in the era of COVID, where any child at that daycare or any teacher at that daycare could close that daycare down any day, I think it's very risky.
And I respect and understand that if you can find some law on it, go ahead and find some law on it. Let's not do it now. But on Monday or wherever it may be, because we've got a little bit of time, I'll take a look at it, and I'm just going to ponder it a little bit more. I do find that she's qualified. Again, the court's already stated with the way I look at the exemption requests, that was not specifically made in this case. She didn't make it on the record here, and I don't even think she was asked, other than those general questions, whether or not she would avail herself of that. She talked about daycare and how she's covering that. So that's what the court has in the record. Okay.
Before we finish the day, I would like to take up one last matter. Your Honor, I'm letting the court know at the earliest practical opportunity that we're looking at challenging the array pursuant to the 6th and 14th Amendments to the United States Constitution and parallel provisions of the Georgia State Constitution. I can't say I've been in this situation before, and all the jurors I've picked in Glynn County, but in this case, it would appear that white males born in the South over 40 years of age without a 4-year college degree, sometimes euphemistically known as Bubba or Joe Sixpack, seem to be significantly underrepresented. I can't say underrepresented in the entire panel of jurors because the race information on the master list is obviously not inaccurate. Also, that list is missing crucial information to identifying this group. So there are 2 issues. The one issue is whether that is a cognizable class. If it's not a cognizable class, then that's really the end of the discussion. If it is a cognizable class, then figuring out what the appropriate evidence would be and what the standard would be is much less settled. As I understand it, to be a cognizable group for constitutional purposes, there must be some quality or attribute in existence which defines or limits the membership of that group. Second, there must be a cohesiveness of attitudes, ideas, or experiences which serve to distinguish the purported group from the general social milieu. Third, community of interest present in the group may not be represented by other segments of the population. With all due respect, and without meaning to be stereotypical in any way, I do think there's a real question in this case, whether that demographic is underrepresented in this jury pool. And if it is, then we have a problem with it. All I can see from having practiced law here for 40 years and been involved in selecting at least 100 juries in this courthouse, but in Glynn County, is that there's a demographic that has been dramatically underrepresented to the norm that I've witnessed since 1989. And I believe that it is an issue that will need to be addressed. And I know the court hates to be put in position of being surprised with things at the last moment. So I want to put the court on notice that that's an issue that we're looking at.
Thank you. Anything further from the state?
Nothing further from the state?
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
All right, let's go ahead and get these members of panel 7